Well, welcome to another Rogers Capital Market Commentary, where we attempt to be the antidote to water cooler wisdom. Well, happy summer. The 100-degree temperatures are on the way. Here's wishing you a great, leisurely, relaxing summer. Plenty of time with family, and hopefully from some travel and fun as well. Well, June has had a real good start for us so far. May was flat, which leaves us through the first 5 months of the year at about an 8 or 9% gain on the S&P for the year. It appears that the Fed's approach to stamping out inflation, the tightening policy, is working. But I thought, instead of rehashing the same several points that we have been in previous videos, from inflation to the Fed to earnings to kind of the cyclicality of things that happen in a tight monetary policy time frame, thought we'd spend a little time on something else. The 4.5 estate planning documents that you may need regardless of age or health or wealth. And you heard that right, 4.5. We'll come back to that. Now, I'm not an attorney. I don't practice law. I don't write documents. But as a certified financial planner, one of the disciplines that I'm responsible for in helping clients is the knowledge and review of estate planning. Now, when I say estate planning, most folks think will. And actually the will, and then there are several ancillary documents that are useful to clients. So let's run down the list. Number one is a durable power of attorney. A power of attorney protects you, your property, in the event that you become physically or mentally unable to handle financial matters. It authorizes someone else to act in your stead and on your behalf to pay everyday bills, expenses, to collect benefits on your behalf, to watch over your investments, to file taxes for you. Okay? Now, 2 types of powers of attorney. One is the immediate power of attorney, meaning once you've signed that document initially, had it witnessed, etc., it is in force. Someone else can act on your behalf. The second type is what we call a springing power of attorney. It's not in effect now, even though you've signed the paperwork. No one can act on your behalf until, usually, a doctor, a couple of doctors sometimes, certifies that you are unable to physically or mentally, cognitively perform on your own behalf. Now, at first glance, you'd think, okay, well, I don't necessarily want somebody to have the ability to do it now. I'll do the springing power. Unfortunately, the springing power comes with it quite a few issues. In fact, increasingly in this society of ours, due to lawsuits, the liability that financial institutions and banks have, they're becoming much less likely to accept one of these types of powers of attorney. And really, maybe the even larger issue is we're starting to see quite a bit of trouble in getting doctors to sign off on these things. In fact, I had a client not long ago that was in an Alzheimer's facility, and we couldn't get the doctor who was treating her in the facility to sign off on the incapacitation because, well, they just don't do that as a policy. So tough to have a power of attorney that's springing, and either you can't get the medical personnel to sign off on it or you can't get financial institutions to accept it. So in most cases, the attorneys I have worked with recommend that you go with immediate powers of attorney. So that's the first ancillary document. The second, advanced medical directives. Now this encompasses three things, but these let others know what medical treatment you would want, or allows someone to make medical decisions for you. A living will is the first example. What does that do? Well, that expresses your intent, your will to remain among the living, provided A, B, C, and D exist. And if not, then pull the plug. Living will. My will to remain among the living, provided these circumstances. If not, let me go. The second advanced medical directive is the durable power of attorney for health care. So like the one we just went through for financial matters, but just for health care. Experimental treatments that you might want to participate in. You might not necessarily want to just do whatever the doctor says, but have someone else chiming in to say, yes, they want this extra effort or this experimental, this, that, or the other. The third you may have already heard of, which is a DNR, a do not resuscitate. If I am gone, let me go. Do not resuscitate. The third document to point out is probably the one, again, more people think of when I say estate planning, but that's a will. So a will is going to distribute your property after death. Property that's not transferred otherwise, okay? A couple of things there. The first is after death. Your will is barely worth the paper it's written on until you pass. It can do nothing for you until you pass. Then it springs into action. It is useful at distributing your property through probate. Now, the will is only going to pick up and transfer what is remaining in your estate. What do I mean by that? There's lots of property that transfers before it ever gets to your will. Jointly owned property. If I have two folks that own something, one passes away, it immediately becomes the other, either spouse or it can be kids or whoever owns it jointly with somebody. Another type of transfer that precedes that are beneficiary assets. Your IRAs, your 401ks have beneficiaries on there. When you pass, it goes to the person whose name is on there. It doesn't go into your will unless there's no name listed there. It goes to that person. Skips, bypasses, probate. TOD is another thing. POD at the bank, payable on death. TOD in investments counts is transfer on death. Another route that things will transfer. Life insurance is a beneficiary asset. It's going to go to the beneficiary who is listed on there. But the will is going to pick up everything else that doesn't transfer otherwise and run it through probate. Now some of you are saying, well, I don't have a will, which is kind of a funny joke because everyone has a will. You either have one you have prepared for yourself or your state has one for you. Most of you being here in Texas, Texas has an intestacy order. It has a process by which your property is going to transfer. So you can put the effort into doing this yourself according to your wishes or your state. I assure you, your state will do it for you. So it's your choice. Now, it's crucial that your will be well written, articulated, properly executed in your state. In Texas, most of you here in Texas, that means two witnesses, that disinterested, witnesses. They can't be people whose name are in there, family members in there. And then notarized would be great, not necessarily required, but notarized. Two disinterested witnesses and notarized, okay? And also important to keep your will up to date. That means every 3 to 5 years, looking through it, updating the names. You may need to change and shuffle around some of the beneficiaries if your kids aren't acting right? So that's the will. Number 4, a letter of instruction. Now, this is an informal, non-legal document that's used to express personal thoughts, directions, your wishes regarding what's in the will, maybe burial wishes, memorial, instructions, maybe the location of important documents. But it can be hugely helpful to leave for your family members. It's private. It doesn't go into the court record. It's private. Gives you a chance maybe to say some things that you'd rather not make public. Now, it's not a substitute for a will. It can't do what a will does. It can't transfer property. It's not even a legal document. It's just suggestions. It's not binding at all. So that's 4. 4.5, here's the half, and that's a living trust. So why half? Well, a couple of reasons. One, not everybody needs a living trust. Number 2, you would usually, if you just need a simple will, you'd go the will route. You don't need a living trust and a will. Now, if you get a living will put together in the big binder, there's going to be a will in there, a pour-over will, they call it, to pick excess stuff you forget about and run them through your probate too. But usually you're going to do one of the other of these strategies. So the living trust, again, not everybody needs one. Now, you will get invitations in the mail for steak dinners, selling trusts as the cure for everything, from keeping Medicare from taking your home to saving you on taxes and guaranteeing investments and curing cancer. I mean, they do everything, only they don't do any of the things that they suggest. What they do, number 1, is avoid probate. They're a private probate alternative. So instead of running a will through the public record, a living trust is a private matter. For those of you in smaller towns or areas where you don't want everybody in your business, a will is going to be posted on the county record. Anybody can come in and see what you want, what you had. If you want that to remain private, a living trust would be a better alternative to that. Out-of-state property is a huge deal. If you have things in various states, homes, land, whatever, you don't want to have to probate something in each of those states. And so a living trust that can funnel all that stuff through one process, that's a huge advantage for living trusts. I've even in recent years kind of suggested folks consider this if there's a history of cognitive things. Now, we have powers of attorney, which we went through earlier, which can help with these processes, but a living trust would make that quite a bit more simpler with 2 joint trustees, even successor trustees that are easy to shuffle in and out if need be, instead of having to go down to a courtroom and get that same process accomplished. Now, last thing I'd mention are folks that have like control issues or this need for control from the grave, let's say, special needs, children, or just kids where they need a little bit more help or protection from spouses or whatever. Life, right? I mean, life happens to all of us. In that sense, in that need, a living trust is going to be a little bit more effective at protecting your loved ones from, we say, in-laws, from creditors, predators, in-laws, and outlaws. So now, if none of those resonate with you, then you probably don't need a living trust. A will would be fine, okay? Now, happy to discuss some of these things further, but thought, a little bit different thing this month. The 4.5 estate planning documents that you may need regardless of age, health, or wealth. Hope you have a happy summer. We'll talk with you soon.